The right to a jury is presented in the Sixth Amendment, which states, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and be informed of the nature and cause of the accusation, to be confronted with the witness against himself, to have compulsory process for obtaining witnesses in his favor, and have the assistance of counsel for his defense." The Sixth Amendment right guarantees the right of criminal defendants, including the right to a public trial without unnecessary delay, the right to a lawyer, the right to an impartial jury, and the right to know who your accusers are and the nature of the charges and evidence against you. Trial by jury is a major part of U.S. checks and balances. A jury trial can differ vastly from a trial where a judge presides over the case. Having the option for a jury trial can be a real advantage for a defendant.
A jury is a body of people, typically 12, sworn to give a verdict in a legal case on the basis of evidence submitted to them in court. The jurors are charged with the responsibility of deciding whether, on the facts of the case, a person is guilty or not guilty of the offense for which he or she has been charged. The jury must reach its verdict by considering only the evidence introduced in court and directions of the judge. A grand jury is a jury typically of 23 people selected to examine the validity of an accusation before trial. Although grand juries and trial juries are both made up of adverse people who were called for jury duty, they serve entirely different purposes. A grand jury helps determine whether charges should be brought against a suspect, while a trial jury renders a verdict at the criminal trial itself.
Even in the very beginning of Rome's conquest, they were very advanced in their way of handling politics. Ancient Rome's legal system served as a foundation of ours and the rest of Western civilization as a whole. Civil trials were handled by people in tribunals with characteristics of a modern-day jury. The judges were not professionals, but rather ordinary civilians to ensure a fair trial. Capital trials, on the other hand, were a lot different from civil ones. Capital trials were seen before a jury consisting of hundreds or even thousands of people. Every year, new judices would be selected. They would be responsible for resolving disputes by acting as jurors, with the praetor taking on the duties of a judge. Roman elites were not able to become jurors because the Roman people feared they would gain too much power. People with a criminal past were also not able to become jurors, much like gladiators for hire, who were used instead in trials by combat.
Taylor v. Louisiana argued October 16, 1974 and decided January 21, 1975. Billy J. Taylor was indicted on kidnapping charges by the grand jury of St. Tammany Parish. The day before his trial was supposed to start, he filed a motion to the small jury that was selected for his trial, because he argued that women were symmetrically excluded, which denied him a right to trial by a jury of his peers. Billy J. Taylor appealed because he thought his Sixth Amendment right was not being upheld and was, quote, tried by an impartial jury to the very uneven amount of women on his case. This uneven amount was because of the state of Louisiana's constitution that stated that a woman could not be selected for jury service unless she had previously submitted a written declaration of her desire to serve. The Supreme Court ruled Louisiana and any other state can now no longer exempt women from the jury solely based on their gender, because it is a violation of the Sixth Amendment and is not an accurate representation of the defendant's peers.
Batson versus Kentucky. In 1982, all black jurors were removed from the Batson's case, a black man who was being charged with second-degree burglary. This decision was made by the prosecution. The jury was now made up of all whites. Soon after, there became lots of discussion about this choice to remove all black jurors. This became a problem for the Supreme Court because there was a Supreme Court ruling that should have prevented the prosecution from being able to eliminate all black jurors, but it made this issue a bigger problem instead of fixing it. After the ruling was finished, they came to a decision that there was racial bias in removing all black jurors from the trial. The court was able to find that the prosecutor violated the 6th and 14th Amendment of the Constitution by removing the black jurors from the trial. Black jurors' rights were being taken away from them and they were being discriminated against. There was no real reason given as to why the prosecutor removed all black jurors. Relying heavily on precedents set in Schroeder v. West Virginia in 1880 and Swain v. Alabama in 1965, Justice Powell held that racial discrimination in the selection of jurors not only deprives the accused of important rights during a trial, but also is devastating to the community at large because it undermines public confidence in the fairness of our system of justice. Without identifying a neutral reason why the 4 blacks should have been excluded from the jury, the prosecutor's actions were in violation of the Constitution. Jurors are allowed to be removed from the court case with a reason, but in the case there was no reason for removing the African American jurors. The Equal Protection Clause guarantees the defendant that the state will not exclude members of his race from the jury either on account of race or on the false assumption that members of his race as a group are not qualified to serve as jurors. Batson felt that his Equal Protection Clause of the 14th Amendment is being taken away from him, giving him an unfair trial. The defendant doesn't get to choose the people who make up his or her jury, but the state can't just eliminate members of the jury because of their race. This case was argued in 1985 and decided in 1986.
Gary Duncan is an African-American teenager from Louisiana who was found guilty of allegedly assaulting a white youth by hitting him on the elbow. Duncan got sentenced to 2 months in prison and received a $150 fine on top of his prison sentence. Duncan requested for trial by jury, but his request was ultimately denied. The state of Louisiana argued that their constitution grants jury trials only to those who've been accused of committing a capital crime, and Mr. Duncan did no such thing. His crime was a misdemeanor. Despite this, in a 7-2 decision, the Supreme Court found that Louisiana was obligated to give Mr. Duncan a trial by jury because the right to trial by jury in criminal cases is a fundamental right to every American. This includes Mr. Duncan, and all states are in fact obligated under the 14th Amendment to provide such trials.
This amendment has been extremely helpful for the judicial system. The 6th Amendment allows people to be fairly represented in a community and makes sure no case is biased when deciding if someone is guilty or innocent. This has allowed for fair trials and for people to not be discriminated against. This amendment has helped many people in recent cases. For example, in the George Zimmerman's trial, the Zimmerman jury was made up of mostly old white men rather than people of color. This sparked outrage from the public because they felt the trial wasn't fair, especially since Zimmerman wasn't initially charged with any crimes after killing Tyrone Martin, as the police believed it was just self-defense. If a trial's jury didn't accurately portray the country's racial diversity, then it will raise some concern, which is exactly what happened in this case, and the 6th Amendment helped bring justice to Zimmerman. And Zimmerman was ultimately found not guilty.